fourth year? Excellent, wonderful to see you here today. My colleagues and solicitors from our legal center, and guests, my very warm welcome to you today. As a lecturer of administrative law and environmental law here at the Newcastle Law School, it is my pleasure to have Professor Michael Head, who is the author of the book that I have prescribed this year for my students, Administrative Law, Context and Critique. As I was saying to one of my students, Gareth, today, who I met today, it is not often that students have the opportunity to receive a lecture by the very author of their textbook. So we feel very fortunate to have you here today, Professor Head. As you well know, administrative law is a fifth-year mandatory law core course in your law degree. And if I may say, it's perhaps not the most popular subject amongst the students. Maybe. It is an area of crucial relevance in legal practice. So my primary goal in teaching administrative law this year has been to demonstrate to my students why administrative law matters to their future careers. It is an area of key relevance to the day-to-day work of the solicitors at the Newcastle Legal Center, who work with immigration and environmental law cases. And the topic of today's lecture demonstrates very well the importance of administrative law in the context of questions of law of public importance. But before I call Professor Head, I will properly introduce him. Michael Head is a professor of law at the Western Sydney University. He teaches and writes in the fields of public law, civil liberties, and socialist legal theory. His administrative law books include Administrative Law, Context and Critique, which you're all familiar with, and Calling Out the Troops, the Australian Military and Civil Unrest, both publications by Federation Press. In 2004, he completed a PhD on the passionate legal debates and jurisprudence of the pre-Stalinist Soviet Union, becoming the first PhD graduate from the Western Sydney University Law School. He has other books, one of which I cannot even pronounce the title. It's a name, Evgeny Pashikalis. But the latest one being Emergency Powers in Theory and Practice, The Long Shadow of Carl Schmitt. Please join me in welcoming Professor Head.
Well, thank you very much, and thank you for the invitation. I'm going to tackle a topic tonight which is, I think, of some importance, not just for lawyers, but for society as a whole. I'm speaking about the increasing attempts being made by governments to shield themselves from scrutiny. Since the turn of the century, in particular, governments have sought to expand the scope of executive power and prevent that power from being challenged, whether politically or legally. This dangerous trend has been seen most prominently in the various powers and measures adopted in the name of the war on terrorism, so-called, supposedly to protect the public. There are now, for example, at least 5 different methods of detaining people without trial, either because they are suspected of preparing or assisting a terrorist act, or they have supposedly information about a terrorist act. This unprecedented expansion of executive power, violating the centuries-old principle of habeas corpus, no detention without trial, has been accompanied by a multitude of secrecy provisions. But this drive has occurred more broadly, including to block challenges to the arbitrary detention and deportation of asylum seekers and to stop cases that affect the profit interests of major companies, such as the coal giant Adani. Tonight, I'm going to focus on one insidious means of preventing lawsuits, and that is via the rules of standing. The doctrine of standing is one of the threads that runs from the Tampa case in 2001 to the Adani coal mine controversies of today. Now, by standing, I guess most of you know by now, we mean the requirements that plaintiffs must have a particular kind of recognised interest at stake in the official decision that they wish to fight. Now, there is an inherent contradiction, I've argued, involved here. Administrative law is public law. That is, it's about members of society holding governments and public agencies to account to ensure that their decisions are lawful. It's about ensuring that officials' activities are authorised by law, that they do not exceed or abuse their powers, that they provide fair and unbiased hearings before making their decisions. Yet standing requires plaintiffs to demonstrate a particular private interest of a legally recognised variety before they can test the legality of a government action. The common law traditionally requires a plaintiff to show locus standi, or standing, a sufficient or special interest in the matter before being given the right to take action. That is, the plaintiff must show some kind of individual interest over and above the public interest of members of society at large. The common law standing rule also tends to recognise business or financial interests, but not necessarily political, environmental or other public interests. In one leading case, the Australian Conservation Foundation case of 1980, the High Court declined to give the environmental group standing to challenge a ministerial decision to approve a tourist development on the coast of Queensland. The judges insisted that the Australian Conservation Foundation had no special interest at stake, merely what some judges called an intellectual or emotional concern. Now, what's wrong with that? Shouldn't we have more of that? Shouldn't we have more intellectual and emotional concern in society? Is the environment just an intellectual or emotional concern? I think not. Why should that distinction be drawn? Aren't we talking here about the future of the planet and basic civil rights? Before turning to the Adani and Tampa cases, I want to emphasise that standing is not the only means by which governments can seek to shield themselves from legal scrutiny. The Administrative Law Council report of 2006, the scope of judicial review, surveyed contemporary methods to restrict access to the courts. These include what we call privative or ouster clauses, provisions to limit the grounds of review, ministerial or administrative so-called conclusive certificates. Also on the list, provisions stating that non-compliance with statutory requirements do not affect the validity of decisions, and the imposition of time limits for initiating proceedings, and so-called non-compellable powers, also becoming more common, that a decision maker is under no duty to exercise a power. There's also the use of wide and subjective discretions, including politically loaded terms such as public interest, which make it very difficult to challenge. Finally, we have, of course, privatisation of decision of public services. We also have, of course, very high fees and charges, both in courts and in tribunals. There is a gap in this area of law, as in all areas of law, between legal theory and the financial and practical difficulties that confront ordinary people in asserting their rights. And these barriers are heightened by cuts to legal aid. Now, we know that the jurisdiction of tribunals and courts can also be curtailed or even scrapped altogether. The only courts immune from that are the High Court and the State Supreme Courts, as clarified by the decisions of the High Court in the plaintiff S157 case and the Kirk cases in 2003 and 2010. There's yet another potential barrier, the doctrine of non-justiciability. Decisions made under the so-called prerogative powers, dating back to the British monarchy, such as the appointment and dismissal of prime ministers, decisions relating to foreign policy, declaring war, signing treaties, and matters such as the award of royal honours and knighthoods, like that given to Prince Philip, are regarded as being outside the purview of the courts. Some of the most important decisions that governments can make, such as going to war, are beyond challenge. Nor was there any attempt to challenge the Governor-General's use of the prerogative powers of the Crown to dismiss the Whitlam government in 1975. Let's now turn to the doctrine of standing and examine what happened in the Tampa case. In 2001, the High Court declined to rule on the legality of the detention and expulsion to Nauru of 433 Afghan refugees who had been rescued by the Tampa, a Norwegian container ship. This was the beginning of the so-called Pacific solution. Liberal national governments and Labor governments alike have barred entry to all refugees arriving by boat and forcibly transported them to remote Pacific islands to be detained, effectively indefinitely, without charge or trial. Nauru was the first location. Papua New Guinea's Manus Island became the second. Both are near the equator, very isolated, and thousands of kilometres away from Australia. When the Tampa case got to the federal court, in the case called Ruddock and Vidalis, the Liberal National Government of Prime Minister John Howard argued that the Victorian Council for Civil Liberties and the Melbourne solicitor Eric Vidalis had no standing to seek a writ of habeas corpus, demanding that the asylum seekers be brought back to Australia to allow their refugee protection applications to be determined according to law. That's a picture of the refugees crammed on the deck of the freighter which rescued them. Now, the government argued that there was no standing, despite using military force to prevent lawyers from communicating with the refugees to seek instructions. The federal court and the full federal court left the issue of standing aside, and that question was not ultimately determined. That was because the High Court eventually refused to hear the case on the grounds that by the time it got to the High Court, the asylum seekers were already in Nauru and therefore outside the in a foreign jurisdiction. I've written on that case in detail in the Griffith Law Review, 2002. The Howard government employed SAS troops to prevent the rescued asylum seekers from being landed in a safe harbour at Christmas Island. Soldiers detained the refugees on the deck of the Tampa and eventually transferred them to the HMAS Manoora, a naval troop carrier, for transportation to Nauru, nearly 7,000 kilometres away. The full federal court ruled that the government had vague executive or prerogative power under the Constitution to detain and remove aliens and take any other action it considered necessary to protect so-called national sovereignty. The Melbourne solicitor Eric Vidalis asked the High Court to reinstate an original habeas corpus order that was made by Federal Court Justice Tony North, who ruled that the government had flouted its own migration legislation and had determined at the highest level to use an unlawful process to detain and expel the rescuees. Justice North, in the initial federal court hearing, ordered the government to bring the Tampa refugees to the Australian mainland, where they have the right to apply for asylum under the Migration Act and the 1951 International Refugees Convention. Now, I'm not in favour of detention, onshore or offshore, but that's what the law said at the time. It's what the Migration Act said, quite specifically. They had to be detained, brought ashore and detained. The government used military force to violate the legislation itself, and then sought to prevent anyone from having the right, the standing, to challenge that unlawful action, arguably unlawful action, in a court. Now, the High Court, I think, wrongly refused to hear the case. In a one-page judgment, High Court judges said the writ of habeas corpus, the claim for the writ of habeas corpus had been overtaken by events, namely the government's forced transfer of the Tampa refugees to Nauru. The three judges asserted that if the persons concerned are now detained, a question about which there has been no trial, each would be detained in a foreign country, subject to whatever is the law of that country. We're talking about Nauru here, a tiny island in the Pacific, a former colony of Australia, so impoverished that the government felt compelled to accept this becoming a holding pen for refugees seeking to arrive in Australia. The judges chose to disregard affidavits showing that the Australian government was paying all the costs of the Nauru detention camp and that Australian officers were overseeing the arrangements there. By summarily dismissing Vidalis' application, the High Court rubber-stamped the military operation against the refugees rescued by the Tampa, in which government ministers deliberately flouted the law. The government, when they sent SAS soldiers on rubber dinghies to turn the freighter away, the government knew that it was violating legislation. It then sought to rush through a border protection bill to retrospectively authorise what it had done. And on federal cabinet instructions, various steps were taken to ensure that the people on board the Tampa could not contact lawyers to challenge the legality of the government's conduct or seek their release from the ship. Government leaders were determined to prevent the asylum seekers from applying for protection visas. According to the agreed facts in the case, the ship has been forbidden by Australian authorities from proceeding any closer to Christmas Island and from entering the port. The effect of the continuing presence of the SAS officers is that the captain and the crew are unlikely to attempt to move the ship into port. This is a consequence desired by the Australian government. The agreed statement of facts went on. The evidence justifies an inference that many of the rescuees would, if entitled, wish to apply for protection visas and would wish to leave the ship and enter Australia. The rescuees have no access to communications with persons off the ship, and persons off the ship are unable to communicate with them. The refugees were shipped away to Nauru, and en route the government crammed 237 more refugees seized off Ashmore Reef onto the Manura, the naval transport ship. Once on Nauru, a desolate island mined out for phosphate by Australia, New Zealand and Britain, military personnel forced the unwilling passengers into a detention camp of makeshift shelters and tents in the middle of the former phosphate mine. Now, Justice North initially in the federal court argued or considered that Vidalis, the Melbourne solicitor, had standing to argue that by preventing him, that is Vidalis, from communicating with the rescuees, the government had infringed his implied constitutional freedom of communication. Justice North emphasised that another issue would have to be determined by the High Court, that is, of the applicant's standing to seek an injunction to prevent the government breaching the Migration Act. So the issue only arose in that form because the government prevented the rescuees from bringing an action themselves. By the way, when it got to the High Court, the government effectively breached an undertaking to bring the refugees back to Australia, which they had undertaken to do in the federal court. And I've argued that the High Court effectively rewarded the government for thumbing its nose at the legal process. Now, as the courts deliberated on the Tampa case, government leaders and media commentators applied intense pressure to the judges, arguing that the terrible events in the United States on the 11th of September 2001 made it essential for the government to wield wider powers. The Commonwealth Solicitor General, David Bennett, QC, told the full federal court that Justice North's decision would restrict the government's ability to avoid such disasters as the attacks on the World Trade Center. In the media, Defence Minister Peter Reith, on the far right-hand side there, insisted that if Justice North's ruling stood, it would open the floodgates for terrorists to enter the country on refugee boats. Without offering a skerrick of evidence, a junior minister named Peter Slipper claimed there was an undeniable linkage between illegal refugees, so-called illegal refugees, and terrorists. Media proprietors and columnists openly called into question the right of the courts to test government action. An editorial in the Sydney Daily Telegraph attacked Vidalis and the Council for Civil Liberties in Victoria for showing what they call suspect judgment. Quote, "The broader issue is the right of a court to act against the wishes of the elected government." Sydney Morning Herald columnist Padraig McGuinness labelled the Civil Liberties Council the Council for Criminal Liberties, and expressed the hope that terror attacks in America would render legal rulings redundant. Quote, "Popular feeling will now ensure that the government will have little difficulty in tightening up on refugee policy so as to diminish the interference of the courts." Writing in The Australian, two ANU legal academics, Robin Craik and John McMillan, insisted that the full federal court should have declined to hear the Tampa case on the grounds that it was non-justiciable. The authors, who are lawyers themselves, described judicial review as a negative disruptive factor. They claimed that discussion of the dispute by national political leaders and the mass media provided an appropriate accountability mechanism, ignoring the manipulative role played by politicians and the media in demonising asylum seekers. So the Tampa case, as well as being a landmark event in political history, the turning away of innocent people also became a testing ground for a potentially far-reaching argument that standing should be used to bar access to challenge such actions. Let's fast forward now to the Adani mine. Urged on by the mining companies and the corporate media, in August 2015, the Liberal National Government stepped up a ferocious attack on environmental groups. It accused them of lawfare and vigilante litigation for challenging the legality of the government's approval of mine projects, particularly a huge coal mine in central Queensland. That's a photograph of the Abbott Point terminal where the coal is due to be unloaded. And of course that's a picture of Prime Minister Malcolm Turnbull meeting the Adani billionaire in India to try to seal the approval of the for the project to go ahead. The business elite, particularly those affected by the collapse of the mining boom, was demanding that the government launch an offensive against all so-called enemies of jobs and growth. Full-page ads in newspapers declared that, quote, green activists are using the legal system to kill Australian jobs. The ads were placed by the Minerals Council of Australia, which represents the big mining companies. The immediate trigger for this campaign and the government's extraordinary allegations was that month's decision by the federal court, with the government's consent, to set aside Environment Minister Greg Hunt's approval of the $16 billion Galilee Basin mine proposed by Adani, an Indian-based conglomerate. In the legal proceedings, Hunt conceded that he had failed, as required by the Federal Environmental Protection and Biodiversity Conservation Act, to give due consideration to the likely impact on two endangered species, the yakka skink and the ornamental snake. Prime Minister Tony Abbott denounced the outcome, accusing the local Mackay conservation group that contested Hunt's unlawful decision of sabotage of the national economy. Using such terms as lawfare, this rhetoric not only voices contempt for legality, it equates legitimate legal challenges to war against the country. Using similar language, Attorney General George Brandis said he was appalled by the court's verdict. Again, this wasn't a court verdict, actually. It was a concession by the minister that he had not considered these endangered species, and a settlement was made on that basis. But George Brandis said the court's verdict was, he was appalled by it. Brandis announced that the government would move immediately in Parliament to repeal the provision in the Act which gives environmental organisations legal standing to object in some circumstances. The government, and this is dealt with in my admin law text, the government argued that the government should repeal Section 487 of the Environmental Protection and Biodiversity Conservation Act, which grants standing to challenge decisions made under the Act to individuals or organisations that have been engaged in environmental activities or research for at least 2 years. So factually misleading were the government's vitriolic accusations that the federal court itself issued a rare statement seeking to correct the reports being splashed all over the corporate media. A court spokesman said that in fact the court had made no findings and issued no judgment. Instead, the court's orders quashing the mine's approval, at least for then, for temporarily, were made by consent, that is, with the agreement of Adani and Minister Hunt, because of, quote, an error sufficient to set aside the decision. Now, although Adani, the mining industry lobby and the government all dismissed the error as a legal technicality, Hunt admitted that he'd failed to follow the steps required by law. Legal groups rejected the government's inflammatory resort to terms such as vigilante to describe lawful methods for challenging government decision-making. To justify its agitation, the Abbott government claimed that the mine will create 10,000 jobs. Adani conceded, however, in another legal case, the true figure is 1,464. By the way, it might also destroy some jobs in the Hunter Valley, I believe. Treasurer Joe Hockey condemned, quote, a litany of challenges against a mine that is going to power the lives of 100 million impoverished people in India. In reality, the project would benefit the Adani empire, controlled by a billionaire. As for the litany of challenges, there had been two, the one in the federal court and the other under state environmental laws. In addition, there have been 3 legal challenges to related plans to dump dredged soil in the Great Barrier Reef in order to build the Abbott Point coal port to ship the coal. More broadly, of the 5,500 projects challenged, of the 5,500 projects referred to a federal environment minister since 2000, under this legislation, only 27 have been challenged by environmental groups using this standing provision, which was actually introduced by the Howard coalition government. The state Labor government in Queensland also stridently backs the mining of the Galilee Basin. Premier Anastasia Palaszczuk hopes that projects like Adani's will offset the hemorrhaging of jobs and the state budget produced by the end of the coal mine bonanza that substantially propped up the Queensland economy for years. Adani said it would look at its options if it does not receive an almost $1 billion concessional loan from the federal government's $5 billion Northern Australia infrastructure facility. to build the mine's proposed 388-kilometre railway to Adani's coal terminal on the coast at Abbott Point near Bowen. That's a photograph, of course, of Premier Palaszczuk also meeting and greeting Adani and announcing that the mine was now going to go ahead. The other person there is Greg Hunt, who was the Environment Minister federally at the time. Now, no decision on that loan, that $1 billion loan is due until December, although the federal government is explicitly backing the project. Resources and Northern Australian Minister Matthew Canavan, or should we say now former Minister, admitted it was a potential risk that the Adani mine was relying on a government loan to proceed. I won't speculate on what will happen now to all the decisions that Canavan and Barnaby Joyce and Fiona Nash have made. This will be a minefield for administrative law, potentially, in coming months. But endangered species are not the only issue involved. Scientists have expressed serious concerns about the Adani project's environmental impact, particularly on the Great Barrier Reef, because the seabed would be dredged in nearby waters to make way for coal ships and expansion of the Abbott Point port. The dredging would be detrimental to the reef, or could be, which is already endangered by global warming. Adani currently faces possible fines for discharging coal sediment water from its Abbott Point terminal, which is adjacent to the World Heritage listed reef. In addition, Adani's environmental impact statements, approved by the state and federal governments, have revealed that the mine could require large amounts of water each year from local rivers and underground aquifers. The huge mine also raised the broader issue of the contribution of coal to global warming. Now, in the effect of the government's move to repeal the standing section 487 of the Environment Protection and Biodiversity Conservation Act would have been revert to what we call the person aggrieved test of standing under the ADGR Act, the Administrative Decisions Judicial Review Act. The person aggrieved test is usually interpreted to be something pretty much the same as the special interest test, which the High Court applied in the Conservation Foundation case back in 1980. However, the amendment did not pass. The government could not get the numbers in the Senate to push it through. Now, the ADGR Act language of a person aggrieved, if it were to be interpreted broadly, would give standing to anyone aggrieved by an official decision. But the courts have, as often is the case, interpreted it narrowly to more or less align with the common law special interest test. So in Australia, there is no open or even public interest standing doctrine. The bottom line is the Conservation Foundation case of 1980, which ruled out open standing. That is the right of any citizen to take action to enforce a public duty. With Justice Murphy dissenting, the court rejected the standing of the ACF, the Conservation Foundation, to challenge the minister's decision to approve a tourist development without a final environmental impact statement as required by statute. Although the ACF had previously submitted written comments to the minister on a draft environmental impact statement, the court ruled that the ACF had no special interest at stake. As I said, some judges labelled their interest an intellectual or emotional one. Justice Mason equated special interest to property, business or economic interests, or perhaps social or political interests. Now, it must be noted that legislation can always specify standing. The federal environment legislation is a case in point. Another example is the Freedom of Information Act, Section 11, which grants the right for every person to seek official information and seek review of any decision to deny access. The FOI Act effectively amounts to open standing because every person means anyone, regardless of their degree of connection to or the nature of their interest in the documents to which they seek access. Moreover, Section 11 of that Act says that the right to access is not affected by the applicant's reasons for seeking a document, nor the government's belief as to those reasons. So one of the arguments often made against changing the common law rule is that Parliament can change it, in particular legislation. But the record shows, with a couple of exceptions, that governments have chosen not to liberalise the rules of standing. Now, one of the anachronisms of administrative law also is that different standing rules can apply depending on which remedy is being sought from a court. It's particularly anachronistic that the old prerogative writs which may be difficult to access for other reasons, may have more generous standing requirements. Even mere strangers have been held to have standing to seek prerogative writs. For example, in Rees-Smith ex parte Rundle in 1991, the WA Supreme Court unanimously granted standing to challenge a ministerial planning decision to local, he gave standing to local residents who enjoyed the use of an area of bushland. And in the Truth About Motorways case in 2000, the High Court accepted that strangers have standing to seek 3 writs: prohibition, habeas corpus, and quo warranto. Now, standing is not a problem in cases where plaintiffs challenge government decisions that directly affect themselves as individuals. However, the need for a plaintiff to establish standing, that is, some special interest in an administrative decision, can present difficulties in other cases. And this raises significant issues, I've suggested, for the development of public law and also for the lawfulness of government actions. Why not, as a matter of public policy, and in keeping with the notion of the so-called rule of law, allow any citizen to sue for the enforcement of a public right or duty? If not, there may be no one, apart from the Attorney-General, that is a member of the government, who can challenge an unlawful decision. This can make testing the legality of a government action dependent upon the political interests of the government of the day. I canvassed this debate in my textbook, pages 150 to 159. I won't review it here today, except to say the following. One of the justifications for the standing rule is to protect the courts from so-called meddlesome busybodies. But this argument has been discredited and rejected by the Law Reform Commission back in 1996 in its report called Beyond the Doorkeeper, Standing to Sue for Public Remedies. Dismissing the floodgates argument, the courts would be inundated with litigants, the Law Reform Commission noted that courts have general powers to strike out proceedings if they are frivolous, vexatious, or an abuse of process. The Law Reform Commission also said that the standing rules are unduly complex, confused, and very restrictive. It recommended that any person be permitted to commence a public law case unless the litigation would unreasonably interfere with another person's private interests. I often say to my students, what if one of you were to be deported? Could I challenge that? I would be very aggrieved by such a thing. But for some reason you might not want to challenge it. You might want privacy. You might want not to upset your family, and so on. Should I have the right to take a case under those circumstances? It does raise some issues where a private interest can be at stake in that way. But outside of that, obviously what's at stake is not just that individual student, but the right of all students on visas to be protected and have somebody prepared to stand up for them if need be. To conclude, the law of standing, like administrative law at large, is saturated with political considerations. It's not always so blatantly stated as in the Tampa and the Adani cases. Far-reaching attempts are being made to curtail legal challenges in ways that would permit governments and the corporate elite to ride roughshod over the needs, aspirations and basic legal and democratic rights of the majority of the population. As students, academics, lawyers and members of society, we need to oppose every move to restrict access to judicial and other forms of review of executive power. Thank you very much.
Thank you very much, Professor Head, for your insightful analysis of the use of standing rules by governments to shield themselves from legal scrutiny. I have invited my colleague, Dr. David Tompkins, to be the debater for tonight. And although he doesn't need any introduction, I will introduce him formally as well. Dr. David Tompkins is an Australian lawyer with degrees in commerce and law and postgraduate qualifications in law from the United Kingdom and Germany. He is admitted as a legal practitioner of the Supreme Court of New South Wales. His doctoral thesis in the field of comparative constitutional law, focusing on the limits to judicial power or non-justiciability in U.S. federal and English public law. Prior to undertaking postgraduate studies, Dr. Tompkins worked in Sydney as a tip staff and judges associate to 2 judges in the Compensation Court and Dust Diseases Tribunal of New South Wales. He subsequently spent a number of years working for various research and public policy institutes in Germany, the United States, and New Zealand. Before joining the University of Newcastle, he was an academic visitor and research assistant at the University of Auckland and a tutor at the University of Sydney. Dr. David Tompkins.
Well, thank you for those kind words. A lot of familiar faces here. It's always good to see students I've taught. This is not the first time Professor Head and I have met or crossed paths. I must confess he's an old teacher of mine. I'm a graduate of the University of Western Sydney. Professor Head taught me not administrative law, I must say, jurisprudence. And it's good to see him again after all these years. So I would like to thank Professor Head for his spirited presentation. And now, to the uninitiated, the very words administrative law no doubt bring up mental images of sections, subsections, paragraphs, subparagraphs, clauses and subclauses of turgid bureaucraties of the kind that would make Sir Humphrey Appleby in an episode of Yes Minister seem like a hopeless amateur. Well, I must admit that administrative law does have its fair share of ministerial thingamies and departmental whatsits, and that the language of administrative law instruments would not win any prizes in placating the gods of plain English drafting. As Professor Head's lecture made clear, administrative law is an important, and if I'm not too biased, an interesting area of law. One of the comments I often get from students, having taught administrative law in the past, at the end of the semester is that, along the lines, I really thought I was going to hate this subject. It was the most boring subject. It would be the most boring subject ever. But actually, it wasn't so bad, and some of the cases were not hard, not too bad. So yes, admin law contains its fair share of turgid bureaucraties, but it also contains more than its fair share of hot-button issues. The kind of issues that the people outside the confines of a course of administrative law even venture to talk about. Not all subjects in law school can boast that. Now, of course, while the fact that admin law can and does involve a number of hot-button issues, it makes it an interesting subject. It also presents some particular challenges for the courts. Challenges which, although not entirely absent from other areas of law, are particularly acute in administrative law. And rules of standing are one such area. Now, as Professor had mentioned, there are some other areas as well, such as rules of non-justiciability and privative clauses. And in his book, Professor Head makes a spirited case for essentially unrestricted standing in administrative law, and I suspect, although I'm not entirely sure, would you advocate for unrestricted standing in constitutional law as well? Or is that something you're just not really concerned with as an administrative lawyer?
Yes, probably.
Right, yeah, okay. So now, as tonight's topic is administrative law, I won't say much. I'll restrain myself from saying too much about standing in constitutional law, as much as I'm tempted to as a constitutional lawyer as well as an administrative lawyer. I will simply say that it's an important topic in constitutional law as well, and not unrelated to the issue in administrative law. Indeed, the boundaries between constitutional and administrative law can be fluid and not entirely clearly demarcated. Now, I do plan to make some remarks about standing in general, but before I do, in the spirit of open debate, not so much personal criticism, open debate, I do want to raise a few questions and matters in reply to some of the things that Professor Head said about the Tampa case and the Adani case, and how these relate to his overall thesis. So Professor Head advanced the thesis that rules of standing are one insidious means of preventing lawsuits, and furthermore that the doctrine of standing is one of the threads running from the Tampa case in 2001 to the Adani coal mine controversy today. Now, I would argue that the second statement, that standing being a thread running from Tampa to Adani, is true insofar as it goes. Both of these, and other cases in between, have indeed given rise to arguments about standing. But I would argue that we really need to dig a little deeper and see exactly what particular role standing played in these and other cases if we're going to make arguments and draw conclusions about it being an insidious means of preventing lawsuits. Now, the first statement is more controversial. What was Professor Head's first statement? That the rules of standing are one insidious means of preventing lawsuits. It contains both a factual proposition, namely that rules of standing act to prevent lawsuits, and a value judgment, that this is an insidious means to prevent lawsuits. The factual statement is again true insofar as it goes, but it too invites us to dig deeper and to ask how and why rules of standing prevent lawsuits. And perhaps more importantly, whether they prevent lawsuits which wouldn't be prevented by other means, or whether they end up just preventing lawsuits which would have been prevented by other doctrines were we not to have standing in law. Now, the value judgment in Professor Head's argument is, like many, contestable. I imagine that some people in the audience would wholeheartedly agree with Professor Head's assessment, that others would strongly disagree, and that others still would be somewhere in between those two poles on a spectrum. Now, turning to the Tampa case, I might have misunderstood what you said, and if so, please do correct me. But I took you to say that in the Tampa case, the Commonwealth argued that the applicants, that's Vidalis and the Victorian Council of Civil Liberties, had no standing to seek a writ of habeas corpus. But on my reading of the case, I don't know if that's correct. There are other standing arguments that the Commonwealth made, but when it came to habeas corpus, the Commonwealth, as I read the case, actually conceded that Vidalis and the Council of Civil Liberties had standing on that point. But then they argued, and the arguments about standing were about the other remedies of certiorari, not certiorari, so mandamus, injunction and declaration. We'll get onto that in a minute. Now, it has long been the case that a stranger can sue for habeas corpus, and the Commonwealth did not seek to challenge this in the Tampa case. Rather, the Commonwealth argued that although the Council for Civil Liberties and Vidalis had standing to seek habeas corpus on behalf of the rescuees, habeas corpus would not lie because the elements were not made out on the facts. And this is an argument which Justice North rejected at first instance, and then which went on appeal to the full federal court. And the full federal court split 2-1 on it, and controversially so. And for those of you who've studied constitutional law, that was the area, and remember we looked at the prerogative, and we were talking about this divide in the case about the prerogative in the Tampa case. One of the reasons the full federal court split in the Tampa case was, did the Commonwealth have a right under the prerogative to detain these people, contrary to the statute? So if I was going to criticise the Tampa case and the decision of the Tampa case on habeas corpus, I'd probably start with their analysis of the prerogative rather than the standing. Now, it is true that standing arose in other aspects of the case, and controversially so, and did have the effect of denying, effectively, the litigants' relief. Now, what were the standing issues in that case? And I mean, the facts of the Tampa case are interesting and, I must say, very unusual. In addition to seeking habeas corpus to order the release of the rescuees from the ship and have them returned to Australian territory, the Victorian Council for Civil Liberties and Mr Vidalis also sought mandamus to compel the performance of what they argued were duties under the Migration Act, an injunction to prevent the Commonwealth from interfering with the ability of the rescuees to engage in communication with solicitors in Australia, and a declaration about the rescuees' entitlement to land in Australia and communicate with Mr Vidalis. And it's in these areas that they ran into problems with standing. And this is what Professor Head alluded to with some of the arcane distinctions in the common law with standing, depending on what remedy you seek. And so to my mind, what's interesting about the Tampa case is not so much arguments of standing in respect of habeas corpus, but arguments in standing in respect of the other remedies sought, and how, for historic reasons, which remedy you seek determines the approach to standing. Now, and the other thing I think that's really interesting about the Tampa case is the very unusual circumstances. The Tampa case is a little bit different from a number of environmental cases. With a number of the environmental cases, absent any provision like Section 487 of the EPBC, Environmental Protection Bioconservation Protection Act, you can get cases where no one has standing to bring a claim, even though there's allegations of unlawful action on the part of the government. In the Tampa case, Tampa case was not an instance of no one having standing to challenge the government's allegedly unlawful action. The rescuees undoubtedly had standing, not just in respect of the habeas corpus claim, but in respect of the others too, the mandamus, injunction and declaration claims. The rescuees themselves had standing, and rules of standing would not have prevented them from bringing that case. What prevented them was their physical inability to turn up and register an action in court, or to instruct solicitors in Australia to do that on their behalf. So that was very clever use of the government, right? So to my mind, one of the interesting issues that the Tampa case gives rise to, right? So it does give rise to the question of, should we just have open standing? Anyone can bring a case. But even if you accept that there are instances where we should have some standing rules, in unusual circumstances like the Tampa case, where the people with standing are unable to bring the case, should there be provision to relax rules of standing so that others can do it? Now, if time permits, I don't know how much time I have. I will say a little bit about standing rules. So, Dr. Idas, how much time do I have? Pardon? Until 6? Right, I will finish up. No, okay, so now Section 487, which in the environmental legislation, is an interesting provision, and I'd be interested in hearing Professor Head's views on a few questions about that. So it represents an ad hoc expansion of standing. So we have the general law position at common law, which is the ACF case. We have then under the ADJR Act, which is worded differently in the statute, but has been interpreted largely similarly to the common law test. And then we have ad hoc expansions where parliaments can, in instances, create legislation to expand standing beyond the general law position. And they've done that under Section 487 of the EPBC Act. Now, so two questions, really, for Professor Head. What, in your view, if anything, is so special about environmental litigation that it warrants expanded standing? Because there are a lot of other groups that are concerned with other public interest issues that would probably like expanded standing along the lines of the EPBC Act, but don't have it. So would you make a case that environmental litigation is special and that it should have broader standing than other areas of public interest? If you wouldn't, and presumably you would probably say, well, everyone should have the same broad general standing rules. But if you can't have that,